It's the Acting Income Podcast with Ben Hauck, episode 34. Why you should vote no for the SAG-AFTRA commercials contract.
It's the Acting Income Podcast with Ben Hauck. Turn your passion into income, Ben will show you how. With all the resources that you need to make it as an actor in an expensive city. To stay balanced and make money, you really can't go wrong with actingincome.com.
Welcome to the Acting Income Podcast. I'm Ben Hauck, your host of the podcast on acting, money, and balancing it all. I'm honored to have you listening. If you're new to the podcast and haven't subscribed yet, pull up iTunes or your podcast's app and click the subscribe button. You'll get episodes right as they come out. This is episode 34, titled, Why You Should Vote No for the SAG-AFTRA Commercials Contract. The show notes for this episode have all the important links referenced in today's show, which you can pull up right now at actingincome.com/episode 34. And now, on with the show. It's April 2016, and if you're a SAG-AFTRA member, you're in a position to vote on the new commercials contract. And if you're listening to this podcast episode, good, because it means you care about the commercials contract, and you want to learn about whether to vote yes or no. And I realize for many of you, you've never even had a chance to work on a commercial. Why would you vote? Well, it may be that you'll work on a commercial in the next 3 years, and the vote you place now may lock in your deal years from now. So it might be a good idea to look into what you're supporting or not supporting so you know what you're up against. If you haven't already figured it out, this podcast episode is about why you should not support this commercials contract. And if you don't vote on it, by not voting on it, more than likely your non-vote will essentially be a yes vote in support of it. And if this contract passes, SAG-AFTRA will probably announce something like that it was supported by 96.5% of members, but declined to say just how many members voted. They've done that before. And there's some evidence from elections that maybe 20% of members vote. Saying 96.5% of members supported the contract would likely be quite a bit disingenuous. So if you get a ballot and weren't going to do something about it, please do open it and cast your vote. And if you don't like what you're about to hear about the contract, please vote no for it. Your no vote will help protect your interests working as an actor in commercials. And even if the contract still passes, the more no votes, the more the union will realize that they did not satisfy the members, and they will be in less of a position to declare extraordinary member support of the contract. Before I dig into the dirty details of the proposed contract, which may make you angry, let me briefly catch you up to speed on it. The 2013 commercials contract was set to expire on March 31st, 2016. On February 17th, SAG-AFTRA and the commercial producers, otherwise known as the JPC, began negotiations under media blackout. They reached a tentative agreement on April 3rd, and the SAG-AFTRA National Board of Directors approved it around April 10th. Now, ballots are going out to members in a vote on whether to ratify this tentative agreement and make it the 2016 commercials contract that would go until 2019. So, to summarize, the 2013 commercials contract has expired, and the new 2016 commercials contract is up for vote by SAG-AFTRA members. Now, commercials are complex, and while I am no expert in them, let me describe some basic principles. The 2013 agreement, which just expired, includes 3 paragraphs, which explain a lot of the logic of why actors are paid as they are in commercials, and I found them really interesting. You will too. They say, compensation to principal performers in commercials is based both on the services which the principal performer renders in the production of such commercials, and on the use which is made of the finished commercial in which the principal performer has rendered services. This dual basis of compensation springs from the unique nature of the services rendered by principal performers in commercials. The union contended that a principal performer rendering services in a commercial performs, to a great extent, the duties of a demonstrator or salesperson of a particular product or service, and as such, tends to be identified with that particular product or service. The next paragraph says, the union also contended that this identification increases proportionately with the continued utilization of a commercial. The union further contended that advertisers and their agencies seldom approve the employment of a principal performer who has become identified with another product or service, especially if the product or service is competitive. These conditions and practices tend to reduce opportunities for further employment in this field. The final interesting paragraph says, the producer, realizing the singular nature of this kind of service and that the reuse of a commercial may limit or curtail further employment opportunities for the principal performers appearing in the commercial, has agreed to this unique method of compensation. All right. So, the basic idea of payment on a commercial is this. You are paid for the day you work. That's your session fee. And you are also paid for use of your work. That's your use fee. And you're paid use fees because you're essentially a salesperson or demonstrator, and the more visible you are as one, the less likely you are to get future work, so you should be paid higher because of that risk of unemployment. Now, if you know anything about negotiation, you know that you usually have two parties who want something. They usually cannot both get everything they want, so they make concessions to the other party in order to ensure getting some things they find important. The result of many a negotiation is some degree of happiness from each party, but also a bit of frustration. In a negotiation, no one leaves super happy. Let's look at what the union is celebrating in their press release. Across the board, they got a 7% increase in wages. This is actually better than the last contract, which got a 6% increase in wages. Sounds pretty impressive, right? What does that amount to in terms of money? Well, if you happen to land a principal role on a commercial, then instead of making $627.75 for 8 hours of work, as you would have under the 2013 contract, you would now make 7% more, which is about $672. You'd get a pay raise of about $44. Then you'd be paid for use of your commercial. You would get hundreds to thousands of dollars more, depending on how and where your commercial was used. In general, the longer and more widely used your commercial, the more money you make in use fees. Now, in this 2016 contract up for your vote, the question becomes, if you get a raise of $44, is that raise a fair price for what you're losing in this contract? The short answer is no, blatantly. Here's one reason why. In exchange for that $44, you are giving up use fees for streaming your commercial simultaneously on the internet and new media, as well as simultaneously on any other kind of new technology that might come along between now and 2019. Simultaneous streaming is an addition to Section 33 of the 2013 contract, and that addition reads, all compensation paid to performers for covered services hereunder grants producer the right to simultaneously stream or otherwise transmit commercials on the internet and/or new media. The foregoing applies to simultaneous streaming, simultaneous cellular transmission, and any other means of simultaneous transmission that currently exists or may hereafter be developed. So, in exchange for a mere $44 increase in your wages, you're supposed to be happy with the free, unpaid use of your commercial on the internet and in new media, streamed, transmitted cellularly, and even transmitted by some future tech that might be developed. Think of it. Your commercial is all over TV, and you go ka-ching each time you see it. But then you see it even more as sponsoring every YouTube video you click on and on every story you read, and you get nothing but the potential for overexposure. You're getting paid $44 instead of the hundreds to thousands of dollars you'd be due from these kinds of uses. Remember the passage I read to you earlier that said the reuse of a commercial may limit or curtail future employment opportunities for the principal performers? Why did the union sign off on the free reuse of your commercial? Doesn't this free simultaneous reuse mean the union is making it harder for you to make money as an actor? And also basically screwing you out of future employment opportunities by exposing your commercial so much? Because aren't you still being a salesperson or demonstrator on a commercial when it's coming through a computer or a smartphone as when you're being a salesperson or demonstrator on TV? If you vote yes for this contract, free simultaneous use of your commercial plainly means that your labor is being used for free. And with television seeming like old media and new media seeming like the future, you wonder if your free labor may be the backbone for future advertising, essentially underwritten by the union. SAG-AFTRA is a labor union. By definition, their labor is valuable. So the union is selling you out, ensuring you do not get paid for use of your labor. This is maybe the most important reason I want you to vote no on this proposed contract. Sit with that thought for a bit, of giving away use of your work on the internet and new media for free. There is another new problem in the proposed contract around use fees, and that's when a commercial is edited. Under most circumstances, if a commercial you were in was edited into a new commercial, you'd get the use fees for both commercials. But this proposed contract gives some of that away when it comes to commercials for special offers or promotions. For example, let's say you did a commercial for the popular fast food chain Vegan Joe's, and it featured a soy burger, and let's say that commercial was broadcast on TV. You'd get use fees for that. But then let's say that the advertiser switched out the soy burger for sweet potato fries, and then broadcast that commercial with you in it. Then let's say it switched out the sweet potato fries for kale chips, and then broadcast that commercial with you in it. Under the 2013 contract, you'd get use fees for these two variations. But in the proposed 2016 contract, the union is giving this away. So Vegan Joe's can substitute new items into your commercial and not pay you use fees when they play those variations of your commercial. An article in Deadline.com about the negotiations touched on this point. The article said a negotiator for JPC had long fought for this for producers and finally achieved it. The article reads, "The negotiator did a solid for McDonald's and Apple," a source laughed ruefully. This means the union again has given away your services for free as a salesperson or demonstrator when it comes to commercials that switch out products or services. How much you're losing out on use fees depends on just how often this happens to you, but methinks it much worse than getting that $44 wage increase. But if this contract ends up getting passed and ends up screwing you out of use fees for variations of your commercial, I found a funny little loophole in this proposed contract that may help you to exploit. And that's with respect to the use of stock footage in a commercial. Stock footage, say, according to Wikipedia, is film or video footage that can be used in other films. Wikipedia also says stock footage is beneficial to filmmakers as it saves shooting new material. Stock footage may have appeared in previous productions. Stock footage is often used in commercials when there is not enough money or time for production. Now, if this contract is ratified, there is a clause that says that the use of stock footage allows for use fees. And it doesn't define the term stock footage, so a plain definition of the term, such as what I provided from Wikipedia, suffices for its meaning. So if this contract sadly is ratified, and if your commercial is edited into another commercial as a special offer or promotion, then your original commercial becomes stock footage inside the variation of your commercial, and as a result of being stock footage, you have an argument for getting paid use fees. Should you find yourself in this predicament, my advice would be to file a claim inquiry for use fees because use of your first commercial in variations of it meets a plain definition of using stock footage, so you should get use fees for variations of your commercial. Let's get back on track, and let's look again at the 7% increase in wages the union secured in this contract. Remember, last time it got a 6% increase, and this time it got a 7% increase. It makes little sense that the union would, by pure muscle, improve on its increase in wages without giving up things of value. I wasn't in the Waldorf Astoria hotel where the negotiations went down, so I don't know what was given up for what. But these losses of use fees for simultaneous streaming and for edited commercials are of extreme value to me. In its proposed contract, the union is giving away use of your work. You're basically being told your services are of value, but only to an extent, after which point your services are free. And when it comes to receiving your payment, it seems that's going to change too. Under the 2013 agreement, you'd get your session fee within 12 working days. But now, no matter if you're a principal performer or an extra performer, that's going up to 15 working days. Now, that doesn't make much of a difference to me, but maybe it does to you. It gives producers a little more time to pay you, but in another sense, it cuts into your late payment fees. So now you have some sense of the bad parts of this agreement. If you turn to the SAG-AFTRA website, and if you find its press release summarizing the proposed commercials contract, you'll probably only see things that sound good. If you don't dig deeper, or if you didn't hear this podcast episode, you would think that this contract is increases. For example, SAG-AFTRA touts in the first bullet point of the press release, quote, over $200 million in wage increases and other payments for all categories of performers. We now know that is a half-truth because there are increases as well as lost income when it comes to your use fees. And while over $200 million in wage increases is one really impressive phrase for the union's resume, what does $200 million in wage increases mean to you, the individual actor? It probably doesn't mean much. What matters more to you, the individual actor, is your wage increases on the types of jobs you work. If you work as an extra performer in commercials, you care about those wage increases. If you work as a principal performer, you care about those wage increases. And in the end, you care about if you're going to take home a lot of money or maybe a lot less money than you realized because the union had bargained away some of the money you were expecting. Surely, an increase is an increase, but you have to ask, since this contract was negotiated for more than a month, would maybe another month of negotiating, motivated by your no vote, yield an increase that makes you much happier and protect use of your work? The union also touts in its press release that they've achieved a, quote, strategic expansion to the definition of a commercial that will help protect the contract's coverage in the area of digital. But if you look more closely, here's what you'll find. They've simply slightly trimmed the definition of commercial. They cut out the 2013 contract wording that said commercials were, by definition, intended for showing on television or intended for showing on the internet or new media. I suppose this implies that something can be called a commercial regardless of its intent, but the word digital doesn't show up anywhere here. In fact, the word digital does show up in a section of the proposed contract that says you don't have to be paid when the producer exhibits your commercial in digital trade publications. So you can blatantly see that the union lost some of your coverage in the area of digital, namely in digital trade publications. But back to this union-celebrated, expanded definition of the term commercials. A side letter included in the proposed contract has this passage that reads, SAG-AFTRA also acknowledges that the study referenced in Section 66 of the contract will include a mutual effort to develop a definition of a commercial that provides clarity to both the union and producers for consideration at the Joint Commercial Review Committee proceedings, arbitrations, and in negotiations for the 2019 collective bargaining agreement. First off, this seems to say that the definition for the term commercial will still be studied during the term of this proposed contract. But second off, I checked out Section 66 of the 2013 contract. It's titled Separability. I read the passage in that section. It says nothing about a study. So I was confused. So I noticed that in Section 65, just above Section 66, there was a section called Alternate Method of Compensation, and that section refers to an Internet and New Media Model Study. I can't for the life of me figure out if this is the study the side letter intended to refer to, but as the contract up for your vote is worded, it refers you to a study in a section of the contract that doesn't mention a study. Unless I'm missing something here, it seems that in the proposed contract, there's a typo. Essentially, during their month-plus negotiations, not to mention their years of past interaction, SAG-AFTRA and the JPC just couldn't get it together on the definition of the term commercial. The definition of the term commercial, rather, will still be studied into the future and revisited. The issue with that agreement is this. They can decide for themselves in the middle of this contract on a better meaning for the term commercial, and you're then stuck with the result. And with the propensity of SAG-AFTRA to sell out your use fees, who knows in what other ways the union will sell you out in hammering out a definition of the term commercial. By this contract, you won't get to vote on that definition because it'll be decided later, and this contract allows for that. Your yes vote would end up supporting whatever definition for commercial they arrive at down the road. Your no vote would help in not ratifying this contract and help force the union and JPC to, come on, define the term commercial now. How hard is that really? Half of you are advertisers. If you've only read SAG-AFTRA's press release about the proposed commercials contract, you'll now see that the union is trying to persuade you to vote for it. The press release is propagandistic. For further example, look at the new rate for stand-ins they mention. If you dig into the proposed contract, you'll see that the stand-ins would get a 10% increase on the background rate. But if you read the press release, they say that stand-ins will get 110% of the general extra rate. Now, both of those things are mathematically the same thing, just in different words. But it's much more impressive to say you've gotten 110% for stand-ins than it is to say you gained 10% more for stand-ins. And it took some conscious thought and calculation to write that 110% figure in the press release, because the percentage 110% doesn't appear in the proposed contract. The mention of 110% is used in the same way we all use 110%, to persuade others into thinking we did more than we actually did. If enough people vote yes, which I fear will happen from only 20% of members, and which I fear the union will promote as overwhelming support, this contract will kick in, and any commercials you worked on after March 31st will get these rates, and you'll get your 7% increase, and you'll give away your own use fees. Well, what happens if you vote no? My thinking is, we're not talking about a strike. We're talking about telling the leadership, who bargained presumably on behalf of you, the actor, the worker, that you need to go back to the drawing board. That use fees, since we are salespeople and demonstrators every time and in every play of our commercials, are more important than a 7% increase in our wages, especially when our work is played online and in new media. That edits of our commercials into special offers and promotions provide us use fees that we demand. That not settling on a definition of the key term commercial is unacceptable. And that maybe you have to go back and correct a typo in the contract you've proposed. A negotiation between SAG-AFTRA and JPC should resemble a game of chicken, though not in its cooperative form where the cars swerve and they knew they were going to swerve from the beginning, but a game of chicken in its competitive form, where the opponents are truly opponents and one may actually not swerve. Not a dignified media blackout while the negotiations go on, but instead a partisan, messy negotiation with leaked information and probably not taking place in the cushy Waldorf Astoria hotel. Maybe put the negotiation in a moldy church basement that many actors know as holding. Be a constant reminder that acting work can suck, and it really sucks when you know you're not getting paid as much as you expected. In short, put the brakes on the proposed 2016 commercials contract. Please vote no. And please share this podcast far and wide. Facebook, Twitter, whatever. Hashtag vote no. Hashtag vote hell no. Thank you for listening. This episode was sponsored by the FICOR Workbook from FICOR Central. To download a copy of the FICOR Workbook and learn about whether going FICOR is right for you as a screen actor, visit ficorcentral.com/workbook. That's ficorcentral.com/workbook. The show notes for this episode are available at actingincome.com/episode34, where you can also leave a comment on this episode. You can also find Acting Income on Twitter and Facebook. Have a story idea? Shoot me an email at actingincome.com/pitch. And be sure to click the subscribe button in iTunes or your favorite podcast app to get new episodes of the podcast. I'm Ben Hauck, #VoteNo. And for more information, as always, check out actingincome.com.